May I request everyone to please take their seats. May I request everyone to please take their seats and kindly switch off your mobile phones or keep them on silent mode. Mic check, mic check, mic check. Mic check. Mic check. आ रही है आप लोग को आवाज? May I request everyone to please be seated? May I request everyone to please be seated so that we can begin? May I request Honorable Justice Oak and Mr. Tushar Mehta to kindly come on the dais, please. Baba Saheb Dr. B.R. Ambedkar once said, "The Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age." This remains true today as it was then. Namaskar and a very good evening to all of you. Honorable Justice Oak, Judge, Supreme Court of India, and the other honorable judges of the Supreme Court of India, Learned Attorney General of India, Mr. R. Venkatramani, Mr. Tushar Mehta, Solicitor General of India, distinguished members of the bar, esteemed guests, and dear colleagues. It is with immense pride and great honor that I welcome you all to this special event organized by the Supreme Court Advocates on Record Association to commemorate the 75th year of the Constitution of India. This milestone is a celebration of the values that define our nation: justice, liberty, equality, and fraternity, principles that have guided us since the adoption of our Constitution in 1950. The presence of Justice Oak and the Solicitor General, Mr. Mehta, today adds immense significance to the gathering. Their insights and perspectives will enrich our understanding of the evolving constitutional landscape and the role it continues to play in shaping our democracy. In honoring the 75th year under the aegis of our President, Mr. Vipin Nair, we are delighted to present a lecture session which aims to serve as a platform for knowledge sharing and deep reflection on the journey of our Constitution. SCORA firmly believes that it is through such intellectual engagement that we continue to uphold and strengthen the spirit of constitutionalism. The participation of our esteemed speakers and each and every one of you present here today underscores the commitment of the legal fraternity to the principles enshrined in our Constitution. Before we proceed with the lectures today, may I request Ms. Reena Pandey, Member Executive SCORA, to kindly felicitate Justice Oak with the planter. May I request Mr. Ranbir Yadav, who's been at the bar for 43 years, to kindly present a stole to Justice Oak. May I now request Mr. Aditya Giri, Member Executive Scorer, to kindly present a planter to Mr. Tushar Mehta. May I request Mr. Krishan Kumar, Advocate, who's been at the bar for 49 years, to kindly come and present a stole to Mr. Tushar Mehta, Learned Solicitor General of India. Thank you, sir. I now would like to call upon Mr. Nikhil Jain, Honorary Secretary Scorer, to deliver the welcome address.
Honorable Justice Abhay S. Oak, Judge Supreme Court of India, and Honorable other judges of the Honorable Supreme Court, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Solicitor General of India, Ms. Rachna Srivastava, Vice President SCBA, Mr. Vikrant Yadav, Honorary Secretary SCBA, Mr. Sushil Tomar, Joint Treasurer SCBA, other office members of SCBA, distinguished members of the bar, esteemed guests, and my dear colleagues, a very good evening to all. It is an honor to welcome you all to this distinguished lecture series commemorating the 75th year of the Constitution of India, a momentous milestone in our nation's democratic journey. This event, organized by Scrora, is a tribute to the enduring values of justice, liberty, equality, and fraternity enshrined in our Constitution, a document that guides our legal system and shapes our nation's future. Over the last year, Scora has ensured that through various lectures, both in physical and virtual modes, the wisdom and experience of genius legal brains is brought out for our advocates on record and others. These lecture series serve as a platform dedicated to knowledge building, professional growth, and meaningful discourse. In an ever-evolving world, the pursuit of learning and engaging in thoughtful discussions, which remains essential for achieving personal and professional excellence. Over the years, this series has brought together distinguished speakers and experts to share insights, exchange ideas, and engage in stimulating conversations that enrich our understanding and broaden our perspectives. We hope that these sessions will continue to catalyze deeper reflection, foster continuous learning, and drive impactful professional development. We are privileged to have amongst us Justice Abhay S. Oak, Judge Supreme Court of India, and Mr. Tushar Mehta, Solicitor General of India, two legal luminaries who will share their invaluable insights on the evolution, interpretation, and significance of our Constitution in shaping India's legal landscape. On behalf of the association, I would like to extend my heartfelt gratitude to our esteemed speakers for their invaluable contribution to this event and for consistently being strong pillars of support of our association, as well as for encouraging all our initiatives. I also extend my thanks to our distinguished guests and all present here. May this lecture inspire meaningful discourse and reaffirm our collective commitment to upholding the ideals of our Constitution. I also extend my heartfelt appreciation to the Executive Committee of SCORA, our dedicated members, and everyone who has contributed to make this event a reality. It is through our collective efforts that we continue to grow as an institution upholding the values of justice, integrity, and excellence. Thank you, and welcome once again.
Member Executive Skora, and it is my distinct honor and privilege to introduce one of the India's most eminent legal luminaries, Mr. Tushar Mehta, the Solicitor General of India. Mr. Mehta, known for his profound erudition, unmatched courtroom acumen, and an impressive track record, Mr. Mehta has firmly established himself as a pivotal figure in India's legal and constitutional framework. Hailing from Gujarat, Mr. Mehta's journey is marked by unparalleled academic excellence. He is the recipient of multiple gold medals during his time at Gujarat University and Gujarat Law Society, including the prestigious Nani Palkiwala Medal. Recognizing his contribution to the legal profession and public service, he has been conferred honorary doctorate by Karnataka State Law University and Amity University, Noida. With a legal career spanning decades, Mr. Mehta has held several prominent positions. He began his practice at the Gujarat High Court in 1987, earning a stellar reputation in constitutional law, criminal law, and corporate litigation. Over the years, he has served as Advocate General of Gujarat, the Additional Solicitor General of India, and since 2018 as the Solicitor General of India. Mr. Mehta has represented the Government of India in numerous landmark cases, including the historic Ayodhya title dispute, the constitutional challenges surrounding the abrogation of Article 370, and critical economic reforms related to GST and insolvency. During the pandemic, he effectively defended the government's policies on vaccine distribution and lockdown management, showcasing his commitment to national interest. Beyond the courtroom, Mr. Mehta is deeply committed to education and policy making. He is a member of the Governing Council of the National Law University, Delhi, and Indian Law Institute, as well as ex officio member of Academic Planning Board at Rajiv Gandhi National University, Patiala. He also served as patron member of the Bar Council of India and the honorary president of the Arbitration Bar of India. On the global stage, Mr. Mehta has represented India as the lead delegate to the United Nations Human Rights Council during the 41st session at Geneva, exemplifying his diplomatic acumen and legal expertise. A strategic thinker and a meticulous advocate, Mr. Mehta is celebrated for his deep understanding of constitutional principles and his ability to balance assertiveness with decorum. His leadership extends beyond the courtroom to mentoring young lawyers, shaping policies, and strengthening the legal profession in India. Please join me in welcoming Mr. Tushar Mehta, a beacon of legal excellence and a true guardian of justice, to address us today on the topic 75 years of the Supreme Court as the guardian of the Constitution, evolution, challenges, and way forward. Please.
Good afternoon, everyone. My Lord Justice Oak, my friend Vinit Nair, Amit Sharma, Nikhil Jain, Honorable Justice Bindal Saab, my Lord Justice Dipankar Datta, Justice Jaimalya Bagchi, Justice Vishwanathan, my senior, the learned Attorney General for India, and my dear friends. On December 11, 1946, when the task of framing the Constitution had only just begun, the future President of India, Dr. Sarvapalli Radhakrishnan, stood up to speak. In his speech, he outlined a vision of what independent India's Constitution ought to be. His vision for the Constitution can be expressed in 3 words: concord alone is the supreme good. For Dr. Radhakrishnan, the Constitution was a means to bring harmony in all spheres, whether social, political, economical, or cultural. But every concord requires a guardian to maintain it and to ensure that the discord does not creep into the constitutional vision. In India, that guardian found its place in the Honorable Supreme Court of India, which established in Supreme Court of under the Constitution under Article 124. When this establishment occurred on 28th of January 1950, the first Honorable Chief Justice of India, Justice H.J. Kania, also put a great emphasis on the role of the court not only as a guardian of the Constitution, but as a guardian of fundamental rights of the people of the country. His Lordship made it clear that the purpose of the court was to establish and safeguard the fundamental rights and liberties of the people, and that its endeavor would be to interpret the Constitution not as a rigid body, but as a living organism, having within itself the force of power of self-government. Friends, 75 years later, we may take pride in saying that this endeavor has to a very great extent succeeded. The constitutional vision of India remains intact, and the Supreme Court has played a significant role in maintaining it, often through period of great turbulence. Even during the dark days of emergency, for instance, judges such as Justice H.R. Khanna never forgot their responsibility as custodians of the Constitution and fearlessly took up a stand in support of people's rights. The judgments of this honorable court have always opened new vistas in the field of fundamental rights. No longer are the rights of citizens considered to be parts of isolated silos, which are completely separate from each other. The court's judgment have conclusively established that fundamental rights are an integrated whole and must be considered together. The court's decision on Article 14, 19, and 21 in particular have ensured that all three are seen as a collective and comprehensive guarantee of liberty. These three rights, famously described as the Golden Triangle in Minerva Mill's case, have become the bedrock of individual rights of all citizens of this great nation. The judgments of this honorable court have always displayed sensitivity towards pressing social issues. In Shaira Bano versus Union of India, for instance, this honorable court finally put an end to a pernicious practice of triple talaq. This decision gave a fillip to women's rights in India by ending an outmoded and discriminatory practice which militated against the very dignity of women. Article 21 in particular has become a repository for an array of different and variety of rights. The rights-based approach of the Honorable Supreme Court can be seen from the fact that it has always emphasized that the life envisaged by Article 21 is not a mere animal existence, but a meaningful and fruitful existence as a human being with human dignity. Thus, Article 21 has become the base from which a number of rights have been derived by judgments of the court, including right to shelter, right to food, right to speedy and effective legal assistance, and right to have privacy. Friends, the Supreme Court is thus indeed the guardian and the final interpreter of the Constitution and the ultimate protector of the fundamental rights and human rights of the citizens of this great nation. But it is not just a guardian, for it has done much more than simply keeping the Constitution preserved. Every iteration of the court has played an active role in interpreting the Constitution to respond actively to the challenges presented from time to time, depending upon the circumstances under which the Honorable Supreme Court is called upon to save, protect, preserve, and give meaning to the Constitution of India. Whether it be the principle that education is a fundamental right in Unnikrishnan case, the formulation of non-arbitrariness in A.P. Royappa case, or the development of sustainable development norms in Vellore Citizens Welfare Forum, the Supreme Court has ensured that our Constitution is kept both vital and responsive to the emerging needs of the society, since culturally, socially, economically, and in every which way, we as a society, we as a nation have continuously grown, facing new challenges which comes with growth every year. Today, it is our turn to ensure that these hopes continue to be realized. We are confronted with our own set of challenges in this regard. The foremost of these, of course, is judicial pendency. 80,000 cases are pending in the Supreme Court alone. Many deserving litigants are still waiting for years without hearing. Access to justice also remains a major concern. On the one hand, technology has proved to be beneficial in terms of improving access to justice as well as ensuring greater transparency. Litigants in far-off places now do not need to physically come to the court as a result of video conferencing technology, while the recent initiative of live streaming Supreme Court proceedings in select cases has enabled the people of the country to actively observe how the highest constitutional court of the country functions and protect their fundamental rights. The problem was taken note of by the Supreme Court itself in 2022 in Shankarlal Sharma versus Rajesh Kulwal and others. This court had noted that original service-oriented values of the legal profession are gradually being lost over time and had specifically called upon young advocates to volunteer their time to assist the disadvantaged sections in need of legal assistance. Friends, this may not be confined to young lawyers, but to every lawyer who owes a duty to the society to give back to the society what the society has given to him. Another challenge before us is how to respond to the growing role of technology. Technology has many beneficial effects. However, the rise of social media, artificial intelligence, and technologies such as deepfakes have also posed a concern. Indian jurisprudence, which took shape in the earlier era of mass media, particularly the print media in terms of Sakal newspapers and Bennett Coleman and company, will have to be re-looked at from the point of view of the new modes and methods of communication emerging after the invent of internet. A very significant issue before us is the need to re-Indianize our Indian jurisprudence. As noted above, when the Honorable Supreme Court was established, we had set out to build a jurisprudence which was uniquely suited to Indian conditions, Indian character, Indian temperament, and India's social ethos. Somewhere along the way, that goal appears to have lost the significance it rightly deserved to have. In seeking illumination from other sources, the leading lights found closer to home have not been given their due. It is my fervent hope that we rediscover full breadth of our own legal heritage and apply it in its entirety to solving the practical issues which confront our nation, to solve the problems which are country-specific, nation-specific, society-specific, and at times individual-specific. Friends, I am immensely grateful to Mr. Nair, Mr. Amit Sharma, and Mr. Nikhil Jain, and the entire team of SCORA, whom I have witnessed doing their best 24 hours almost since last about 1 month, that I am given this opportunity to have some dialogue with all of you. I'm really thankful to all of you to tolerate me for having said something which was otherwise very obvious. Thank you so much.
Thank you, sir, for your thoughtful insights. Your discourse has provided us with a deeper appreciation for the Constitution and also for the Honorable Supreme Court. I would now like to introduce our second speaker for the day. It's my honor and distinct privilege to introduce our esteemed speaker for today, Justice Abhay Srinivas Oka. Sir is a jurist of remarkable intellect, unwavering integrity, and unshakable commitment for the rule of law. In the Indian judiciary, Justice Abhay Oka is recognized as a prominent figure, celebrated for his exceptional legal expertise, steadfast dedication to justice, and tireless efforts to uphold the rule of law. Born on 25th May 1960, Justice Oak comes from a family with a legal heritage, as his father, Srinivas W. Oka, was a distinguished lawyer. Initially pursuing a Bachelor of Science degree from Mumbai University, With aspirations of becoming an engineer, Justice Oak's path took a different direction. He began his legal career by enrolling as an advocate on 28 June 1983, practicing in Thane District Court under his father's guidance. Over the course of 19 years, he specialized in civil, constitutional, and service matters at Bombay High Court, particularly on the appellate side. On 29 August 2003, he was appointed as an additional judge of the Bombay High Court, and he became a permanent judge in November 2005 and remained in High Court for 13 years. His career reached significant milestones when he was sworn in as the Chief Justice of the High Court of Karnataka on 10th of May 2019, and subsequently as a Judge of the Supreme Court of India on 31st August 2021. Throughout his tenure as a High Court judge, Justice Oak issued numerous rulings aimed at enhancing environmental protection and improving living conditions in Bangalore and Bombay. He particularly noticed for his decisions regarding civil liberties. During the COVID-19 pandemic, he made several rulings to safeguard the rights of the migrant workers and scrutinize the government's response. As the Chief Justice of the High Court of Karnataka, he transformed the court into a constitutional safeguard for the rights of various marginalized groups, including slum residents, sanitization workers, prisoners, and transgender individuals. Justice Oak approached public interest litigations with a serious commitment to the concept of local standi, adopting a facilitative role rather than a command and control approach. In the words of Theodore Roosevelt, "No man is above the law and no man is below it." Justice Oak has epitomized the principle throughout his distinguished career, ensuring that justice is not merely an abstract ideal, but a lenient reality especially for those who need it the most. His commitment for promoting justice, fostering social change, and ensuring administrative accountability is evident in his rulings on various issues, such as right to protest and stipulations of Section 144 of the CRPC, the rights of the urban poor concerning illegal evictions, and the right to shelter, which emphasizes the state's duty to provide for housing for the homeless under Article 21 of the Constitution. He has also mandated the establishment of necessary night shelters for the homeless in urban areas, addressed the right of prisoners, upheld secularism, and affirmed the inviolable right to legal representation. Furthermore, he has taken a stand against the atrocities committed against the scheduled castes and tribes, enforced the prohibition of manual scavenging, and intervened judicially during the COVID-19 pandemic. In a lecture titled "The Role of Technology in Courts, Accessible Justice and Timely Justice" at the High Court of Bombay, Justice Oak advocated for all high courts to adopt the technology to eliminate manual processes and automate the listing of the new cases. He believes that technology will enhance transparency in constitutional courts and their operations. Renowned for his extensive legal knowledge, impartiality, and commitment to justice. Your Lordship will actually today deliver a lecture on the access to justice and 75 years of the Constitution of India, bridging the gap between the judiciary and the citizens. We are honored to have Justice Oak today with us. His extensive experience makes his insight valuable, and it is with great respect I ask you all to join me in welcoming Your Lordship.
My esteemed colleagues, Justice Dipankar Datto, Justice Rajesh Bindal, Justice Vishwanathan, Justice Bagchi, the learned Attorney General of India, learned Solicitor General of India, Mr. Nair, an entire team of SCORA, senior advocates, and members of SCORA. I must confess that I was a bit surprised to receive this invite from SCORA to speak in its function, because last more than 3.5 years, I made every endeavor to discipline advocates on record. And as if that was not enough, I was forced to write a judgment on the code of conduct for advocates on record. And therefore, I must compliment Mr. Nair and his team for inviting me. Till I was judge of the Bombay High Court, I have always avoided one thing. That thing was to indulge in public speaking. But of course, when I became Chief Justice, there was no option. When I became Supreme Court Judge, I was forced to speak on public platforms on a number of occasions. Today, I must clarify the role in which I am going to speak. Firstly, I always believe that only because somebody is judge of Constitutional Court for decades, he does not become a scholar or jurist. I don't know why they describe me as legal illuminary. My only qualification is I am a judge of 3 constitutional courts for more than 21 and a half years. If at all I want to claim a status, I can say that after retirement of Chief Justice Chandrachud, I became the senior most judge of the constitutional courts in India. So that distinction I can always claim. So today, I am going to speak not as a judge of a constitutional court. I am basically going to speak based on my experience, fairly long experience, working as a judge, and about 19 years or 20 years working as a lawyer. As my judgments can go wrong, my personal views can also go wrong, and I am open for correction, because these are basically my impressions on the subject. The title of the subject is Access to Justice and 75 Years of the Constitution, Bridging the Gap Between Judiciary and the Citizens. I don't know whether it is a gap or it is a disconnect, but I'll try to speak on this. On occasion of 75 years of existence of Constitution, I was invited to speak on various platforms, national law schools, private law schools, courts. I have always said one thing which I am going to repeat here. Those who belong to legal fraternity, for them it is not an occasion to celebrate, but it is an occasion to introspect and to find out whether the justice delivery system which exists under the Constitution has really delivered justice. As all of you know, under the Constitution, right is guaranteed, right to justice, social, economic, and political is guaranteed to every citizen of India. Unless our courts of law are able to render quality and expeditious justice, the pledge made under the Constitution to provide social and economic justice to the citizens can never be fulfilled. When I discuss this topic, I always said while speaking on this subject, last 75 years, we means those who belong to legal fraternity, we have committed one fundamental mistake. Whenever on such public platforms, we used to have conferences, discussions, panel discussions. We always discuss Supreme Court and High Court. But perhaps during the last 75 years, we neglected our trial and district courts by describing them as lower courts or subordinate courts. In fact, these are the most important courts. They are the courts of common man. These are the courts where common man can afford to go and knock the doors. Very few people afford to come to High Court or Supreme Court. And therefore, in today's endeavor, I am going to concentrate basically on the subject with reference to our trial and district judiciary. The importance of these courts can be seen on the figures which are there available every day on National Judicial Data Grid. Today's figure shows pendency of more than 4.54 crore cases in trial and district courts. I always wonder, with this kind of pendency, can anyone seriously claim that we have been able to fulfill the expectations of common man from justice delivery system? And that is how a gap or disconnect has been created between the judiciary and common man. There's one more area where I think we need rethinking. I must have attended several workshops, seminars as member of the bar or member of the judiciary. I used to always hear one thing, which is very common, that people say that common man or citizens have great faith in our institution of judiciary as it exists in India. We repeatedly kept on saying that, we kept on patting our backs. I think we had no right to say that. This should be said by citizens. This should be said by litigants. We have to really ask one question to ourselves, whether a citizen is saying this. Not as a judge, but as a citizen of India, as somebody who has gone to grassroots level as working for legal services authority. I have gone to villages, I have gone to prisons. My personal view is that that statement that common man has great faith in our institution of judiciary may not be fully correct. It may not be substantially correct. And this is one area where we need to introspect. If you have pendency of 4.54 crores cases, out of which say 25 or 30% are more than 10 years old, can we still believe that common man has great faith in this institution? And therefore, as I have constantly said this, that we those who belong to legal fraternity, we must acknowledge our flaws and deficiencies in our system. Unless we do that, there is no chance of improving. And that is how today we find that there is so much of criticism in media, printed media, social media, television, of the courts or legal system. I must say that when I began my career, firstly as a lawyer and then as a judge, this criticism was very much there. The criticism was normally within four walls. The second place where this criticism used to happen was corridors of the court. I always believe that corridors of the courts, whichever is the court, is the best place to exercise fundamental right under Article 19(1)(a). I attended a function 2 years back. Somebody asked me a question. After 21 years of judgeship, have you missed anything from your bar days? My response was, I missed only one thing, those gossips and dialogues in the corridors of the court. Sometimes those dialogues are very, very informative also. Of course, electronic and social media has brought about a major change. What was said earlier in low voices, now we hear it quite clearly and loudly. But I personally believe that we as members of the judiciary must take this criticism in stride. The reason is that we should look upon this criticism just to find out whether we are going wrong somewhere. And we should become sensitive about this criticism only when it amounts to a serious contempt. We must hear the criticism, find out whether we have gone wrong, and try and take corrective measures. But if criticism is criticism made for the sake of it, we should ignore it. And I always believe what Justice Krishna Iyer said in his famous judgment in the case of R. Mulgaonkar, where he says that court should learn to ignore the criticism with majestic liberalism. Same is the case with Lord Denning, when he always said that the dignity of the court must rest on surer foundations, and therefore only because there is some criticism, you should not take recourse to contempt jurisdiction. But the question is whether there is justification in this criticism. Maybe there is a scope to criticize. We can't run away from this. We have such a huge pendency. The reasons may be different, but there is a huge pendency, and therefore there is scope to criticize the judiciary, and we must take that criticism very constructively. At least 75 years of existence of the Constitution, we must learn to take it constructively. And we must learn from that criticism. Today we have a scenario where the filing is ever increasing in all trial and district courts. The judge to population ratio, the number of judges per million, has never crossed 23 or 24. there are reasons and reasons for pendency. I'm just going to briefly refer to those reasons, because only if we find out those reasons why people allege that there is some kind of a failure on our part, unless we analyze those reasons, we won't be able to improvise and improve. Other reason is that I'm going to deal with criminal law and other aspects, but one important reason is that we have witnessed a rapidly changing society. And one of the consequences of these changes which rapidly happened in the society during the last 20 to 30 years was rise in matrimonial disputes. As member of the judiciary, this is a great area for concern for me, because now we see happening every day, one matrimonial dispute, unless it is resolved through peer pressure or social pressure, gives rise to minimum 4 to 5 grassroots level litigations. And then there are appeals, revisions, quashing petitions, transfer petitions right up to Supreme Court. So today, one matrimonial dispute is potentially creating, if not more, 15 to 20 litigations at different levels in different courts. And in some of the bigger states, the life of matrimonial litigation is not less than 20 years. Now, this is one category of litigations which is burdening the judiciary. And therefore, this is one area where we have to make innovations and try to resolve these disputes at the threshold. Various high courts have tried different things. For example, Bombay High Court, there is a scheme known as Let's Talk. The idea is the police machinery and other social organizations should refer the couple to the center established under this Let's Talk scheme, so that before they could go to the court, there can be a settlement arrived at with the help of marriage counselors. At various levels, efforts are required, otherwise this system will bring down the judiciary one day. The other issue is, if you look at the statistics published by the National Legal Services Authority, 60% of our prisoners, average 60% all over India, Maharashtra it is almost 80%, are under trial prisoners. This is a result of delay in disposal of the cases. One issue is always why we are not granting bail in obvious cases. Keep aside that issue, because that's a major concern which is expressed by everyone, so I need not dwell upon it at this stage. The issue is something different. There are cases where bail is denied, and in our system, the trial takes years, and maybe after 10 years, 15 years of incarceration, either the trial court or the High Court or Supreme Court grants order of acquittal. I am not talking about those cases where acquittal is granted because of technical ground. I am talking about those cases where acquittal is granted because there is no evidence. We have to someday think about consequences of all this. I have been visiting the jails in Maharashtra. I visited one jail in Karnataka. While having dialogue with the social organizations which work there or the prisoners, one major concern expressed by the prisoners was that it was very difficult for them to get their daughters married. It was very difficult for them to see that their sons and daughters get employment. So in short, the stories which I used to hear was that a person is criminal, let us put it that he is criminal, he is detained in jail, but the entire family is the sufferer. Someday, some litigant is going to question us that when there was no evidence against me, why I was detained for 10 years or 12 years, or even few years, 3 or 4 years. Some litigant is going to question us. And some litigant is going to ask us a question, how we are going to compensate not only me, but my family who has suffered extensively. Because what is the fault of wife or spouse of an accused or children? Why they should suffer? Talking about justice delivery system on the criminal side, there are issues and issues. I'll give you one example of NDPS Act. I'm not an expert statistician, I'm not expert in any field for that matter, but someday experts in the field will have to carry out a survey. My impression, based on my experience, is that those who are coming before the court are accused are only carriers or drivers or those who let out their vehicles. They do it for obviously small consideration because poverty is something which prevails in our society. There is one more area, of course, bail I am not touching today, but one more area which is again area of concern is the position of victim of offense or the first informant. Today we have a scenario where under our system, victim has no control over the investigation. I am not saying that victim should be allowed to control the investigation. But nobody informs him about what is happening in investigation. If he has a grievance about the manner in which investigation is carried out, there is no forum created. All that he keeps on doing is keeps on writing letters to the police officers and is affluent enough to engage lawyers. He comes to a writ court, seeks transfer of investigation. Section 372 of CRPC was amended to give right to victim. That is not good enough because that right is available when there is acquittal. So this is one area where perhaps we have ignored the societal interest because ultimately society is interested in ensuring that a person who has really committed crime should be brought to the book. He should be adequately punished in accordance with law. But if victims have no place in the system, that is one of the disturbing features. And other disturbing feature is that whatever name we call it, but in true sense at grassroots level, there is no real protection to the witnesses. I am not talking about physical protection to the witnesses. When I go to judicial academies, I always elaborate on one subject, that is case management. In our criminal courts and even civil courts, what happens is witnesses are summoned. Now, we must remember that these witnesses are not litigants. We force them to come to the court. Witnesses come and go. There are cases, because we don't manage our cause list properly, we don't adopt case management techniques. So, in a criminal case, eyewitnesses are brought to the court and they are told to go back on 5 days, 7 days, or a span of time. Do we expect them to depose properly before the court? This is apart from the fact that there is no protection to them. And we must also remember one thing. All states are same. What kind of allowances are paid to the witnesses? They have to spend money from their own pocket, travel and come to the court. So in criminal justice delivery system, the witnesses are most neglected. We need to work a lot on that. Because I always believe that it is the duty of the court to grant acquittal if the court is satisfied that within 4 corners of law there is no evidence which proves the guilt of accused beyond reasonable time. We have no scope to give moral convictions. But at the same time, there is societal interest also. So we have to think, those who are stakeholders, they have to think about the other aspect also to ensure that those who are real accused, real culprits are properly tried and they are brought to the book, they are punished. When we talk about this disconnect between the judiciary and common man, one area we have neglected for years together. Look at the pendency in our industrial and labor courts, where workmen or laborers go there. Pendency before the various other fora like Payment of Wages Act, there's huge pendency there. And apart from generally that, barring few states, the trial and district courts lack adequate infrastructure. Labor and industrial courts are most neglected when it comes to infrastructure. There are so many posts which are vacant. I happen to be the chairperson of the committee which selects the members of the National Industrial Tribunal. I can see the pendency and filing. That one area is completely neglected. The other area is legal aid. When we talk about legal aid, we talk about legal aid to the prisoners, to the accused. And what kind of legal aid we are providing? every day in High Court and Supreme Court, we see trials conducted by legal aid lawyers. But of course, there are exceptions. There are exceptionally good lawyers, but generally we find that there is no proper cross-examination of the witnesses, eyewitnesses, unless those omissions and contradictions are brought on record by a legal aid lawyer. No higher court can correct. And maybe because of neglect of the legal aid lawyer, perhaps we may be convicting some persons against whom there may not be any real evidence. There's one more area about legal aid. Supreme Court had taken some steps, I don't know what is the position. Supreme Court had constituted a society under Society Registration Act to create some kind of funds for litigants belonging to middle class. If we take survey of the kind of litigations which are filed in appeals, filed in High Court and Supreme Court, you will realize that large sections of the society, though the verdict is against them, they hesitate to come to higher court because they cost. Imagine a teacher who gets some salary of 20,000, 25,000, or a grade 4 employee who gets salary of 18, 20,000. If he has to travel up to High Court or Supreme Court, can he afford litigation? The answer is no. And then who is going to provide legal aid to them? This is also one question which we'll have to ask. As far as solution is concerned, one area where we have failed, we means all, including government. In 2002, our court, Supreme Court says, increase the just to population ratio to 50 per million within 5 years. Today, we are struggling at 22 or 23. And imagine 2002 and today 2025, the litigation has multiplied, the filing has multiplied, the pendency has multiplied. At least in 2 speeches which Brother Dipankar Datto addressed, he referred to 2016 or 17 order of the Supreme Court, where based on report, interim report of Professor Mohan Gopal, NCMS report, a formula was devised and every state was told to submit a demand for creation of more judicial posts. In fact, one of the speeches Justice Datto shared what happened in Bombay High Court. I was the chairman of the concerned committee. Strictly going by that formula, the figures of additional judges required was something like 12,000. So we restrained ourselves and submitted a proposal for some 8,000 or so. I think only 1,000 posts are created. So how do we deal with this kind of filing and pendency if our just to population ratio remains stagnant at 22 and 23? Of course, we must take blame for pendency, but there is some limit on the capacity of the judges to work. And therefore, unless this area is addressed, maybe after 100 years of constitution, we'll be discussing the same topic, that look at the pendency, matters are not reaching. Unless we make serious effort to implement the orders of the court and increase the just to population ratio. We talk about many seminars I attend of chartered accountants or doctors. They always give me examples of what happens in England or USA. I always tell them, look at the just to population ratio in those countries. Then you will realize why we are lagging behind. And this is a very, very serious issue. It's not enough to create the posts. Sometime back, I attended a workshop where I was told by some of the chief justices that in some states in northern India, the government increased the posts, but corresponding infrastructure was not created. We need courts, we need staff, we need hardware and software, we need residential accommodation for the judges. So it's going to be a very massive thing to be done if you want to increase the just to population ratio. And look at the judicial infrastructure. I'm talking about the biggest judicial district in India, that is Pune. I don't know, about 3 years back, what I learned and I have seen, I must share with you. There are 10 courts of senior civil judges. They are given one room. Before the court hours, it becomes their chamber. During court hours, it is courtroom, and after court hour, it is again a chamber. This is the infrastructure. Of course, now new buildings are coming up. I'm just giving you a representative example that what kind of infrastructure we have provided to our trial and district judiciary. I used to always express happiness Perhaps Karnataka is one of the best states when it comes to infrastructure to trial and district courts. But to conclude on this subject, unless we take some drastic steps, we'll keep on discussing this for 25 years or 50 years, and nothing will come out. And we see that figure of 4.24 or 4.54, which is there today. Maybe we may reach the figure of 10 crores. Now, how this is to be achieved? Now, this can be achieved only with the cooperation of the high courts, cooperation of the state governments. Chief Justice of India constituted a committee to prepare action plan for disposal of old cases in our trial and district judiciary. I am associated with that. Brother Justice Dipankar Datta is associated with that. We prepared action plan, very exhaustive action plan, consisting of 3 phases. I think last phase will come to an end at the end of July. During the implementation, we are monitoring implementation, we realized that there are many states where for more than one court, 2 courts or 3 courts, there is one public prosecutor. Now, if there are no public prosecutors, whatever we say in sitting in Supreme Court, devise action plan, how the cases will be disposed of? If I am not wrong, Section 309 of CRPC provides that concept of day-to-day trial. A sessions case must start on Monday and must go on. But if one public prosecutor is available to 3 courts, how we are going to achieve all this? We will not be able to make any headway in our justice delivery system on the criminal side unless we ensure that there is one public prosecutor attached to only one court. And many funny things happen. I was fairly new as Chief Justice in Karnataka. There was a opening, foundation laying of one new building in city of Bengaluru. I was trying to learn Kannada, but I could not learn. It was after 1 or 2 months after I assumed office. So my colleague was sitting next to me. I told him to act as interpreter. Honorable Law Minister spoke, and his speech, he blamed High Court of Karnataka for not appointing public prosecutors. He was not even aware that who appoints public prosecutors. But you know, everything we learn, we always use that. So next day, first thing I did was to initiate a suo motu PIL, issuing directions to the government to appoint public prosecutors. And the last thing which I want to, the last 2 things perhaps I want to say, is perhaps one thing which we have forgotten during the last 75 years, or at least I don't go back to 75 years, I can speak about, say, last 30 years, that all of us have forgotten that court time is very precious. We have such a huge pendency, and therefore every single minute, single second of the court is very important. When I began practice, I saw lawyers filing very brief and precise pleadings. As a junior lawyer, for first 2 or 3 years, I used to sit in criminal courts and see great lawyers on the criminal side in action. Their cross-examination is so brief and so pinpointed. Now we come across cases. Other day I came across a case, which is not exaggeration. Material was placed on record to show that one defense lawyer cross-examined one witness on 95 different dates, 95. There is no exaggeration. So now, with the passage of time, maybe technology is good. I have always propagated technology, but technology sometimes can be counterproductive. Now today we have entered era of very bulky pleadings, very lengthy pleadings. In Supreme Court, as a student of law, I was told that pleading should never contain law. But we see quotations of judgments in long counters filed in the Supreme Court. Perhaps we have forgotten that brevity is hallmark of great advocacy. And look at the consequence. And of course, I want to plainly say this, that even we have contributed. We also like very long judgments. I can't run away from this fact. But when I go to judicial academies, I have dialogue with the judges. So one district judge, other day I went to Judicial Academy in Karnataka about 3-4 months back. So a district judge said, sir, I commented upon judges writing very lengthy judgments while deciding Section 34 petitions, Arbitration Act. And in many places it goes to a district judges. So he said, sir, I want to say something about it. He said that if in 34 petitions, if petition runs into some 100 pages, there is 200 pages counter and 200 pages rejoinder, and if lawyers throw at me a compilation of judgments, 30, 40, 50 judgments on the same point delivered by different courts, what do I do? If I don't refer to all the judgments in my judgment, all the decisions in my judgment, you are sitting in constitutional courts, you are the one who will be first to blame me. That why you are not referred to so many precedents which are cited. So this is one area where bulky pleadings, long arguments is really threatening our system. And I blame myself for that. I always believe that lawyer can indulge in very lengthy arguments provided the judges permit him. And perhaps it is our failure to control the members of the bar for various reasons. So perhaps the judges will have to also now take a pledge that we will not allow our judicial time to be hijacked by some members of the bar, and will ensure that members of the bar remain in their bounds. So it's all, it's a vicious circle. A lawyer is arguing a first appeal where he finds that there's such a long judgment, 70 pages, 80 pages. Therefore, he naturally indulges in very lengthy arguments. And then there are lengthy judgments. So it's all vicious circle. So someday, members of the legal fraternity, namely lawyers and judges, must realize this, that our time is so important, so precious. The other area is, again, something which very critical, that is an area of adjournments. During last 2 years, I must have visited various state academies in India, state judicial academies. The common complaint by the members of judiciary is that if you are very strict, I'm talking about district and trial judiciary, if you are very strict in terms of adjournments, we face resolution by bar associations. And then there are complaints made to the administrative judges of that district or to the Chief Justice. So adjournments is an area where all of us will have to work. I'm not worried about that criticism in Hindi films, Tariq pe Tariq, because that criticism is made without understanding why dates are given. Therefore, it is high time now, even the members of the bar realize that they are officers of the court first and then mouthpieces of their respective clients. And one more very, very critical area in this. I always taken credit for doing something drastic. When I was in Bombay High Court, I had to issue contempt notices of criminal contempt to about 7 district court bar associations. They continued to abstain from the court work. This happened on 2 occasions. Karnataka, I had to do the same unpleasant job. Coming to Supreme Court, I had to issue notice to at least 2 prominent bar associations of high courts when they abstained from the court work. Forget about the law which says that abstaining from the court work, which amounts to a criminal contempt. It is otherwise very criminal. I'll give an example of a small court. A building with 10 courts in a district. We take any prominent district. You go to any prominent district in India, every court will have cause list of 100 matters. And then if lawyers boycott the proceedings, 1,000 cases will be given dates, 1,000 cases. Imagine the loss and prejudice to the litigants. How we are going to stop this? We refer to what Dr. Babasaheb Ambedkar said on the last day of debates, 25th of November, 1949, when he warned citizens that in independent India, unconstitutional means of protest are completely prohibited. If today lawyers practicing in High Court are taking recourse to this something which is completely unconstitutional, are we not causing great prejudice to the litigants? We talk about huge pendency in bigger high courts. We do talk about it, and there is pendency. We can't run away from that. Now, who is contributing to this pendency? Imagine there are 1,000 bail applications listed before 4 or 5 different benches of one high court. Out of that, at least 150 will be taken. 100 may get bail. If members of the bar boycott the court proceedings, date will be given in those 100 cases where accused are entitled to bail after, say, 2 months or 3 months. Who is responsible for all this? Therefore, to conclude, I am not here to really blame anybody. I am blaming myself, being part of this institution for 21.5 years, that this sort of scenario we are facing. I am not painting negative picture. There are achievements of the judiciary, but today my subject is that I am supposed to speak on the gap between the judiciary and the citizens. And therefore, I must touch all these aspects. And ultimately, when we celebrate so-called celebration we make of 75 years of existence of Constitution, all of us will have to ask a question, a very serious question to ourselves, whether we are really able to fulfill the constitutional guarantee extended to the citizens of providing justice. Answer to this question is very difficult, and that answer can be found out only with proper introspection. And perhaps this year is the most appropriate time to introspect and to bring about drastic changes in the approach of the members of the bar, the other stakeholders, and of course, members of the judiciary. I am really grateful to Mr. Nair and his colleagues for giving me this opportunity. I am more grateful to so many lawyers in large numbers who are present here, who have come after the court hours, and who have been very patient in listening to me, especially when I don't reciprocate that in the court. Thank you.
Thank you so much, Your Lordship, for delivering such an insightful and thought-provoking lecture today. Your words have not only enriched our understanding, but have also inspired us to reflect deeply on the subject at hand and introspect while working towards creating and maintaining the societal balance. Before we proceed to the last segment, I take this opportunity to felicitate Justice Abhay Oak for his wonderful lecture and learning experience, one which we will all reflect and imbibe in our professional lives. May I request Mr. Ankur Prakash, Advocate, to kindly present a memento to Justice Abhay S. Oak. May I also request Mr. Vipin Nair, President SCORA, Mr. Amit Sharma, Vice President SCORA, and Mrs. Nikhil Jain, Secretary SCORA, to kindly present Justice Oak with a small token of our appreciation. Tushar sir, since you will be joining us in the next session, we are going to hold on to felicitating you and showing our sincere and deepest appreciation then. I now request Mr. Kaustav Shukla, Joint Secretary SCORA, to kindly present the vote of thanks and conclude the session closed.
Namaskar everyone present. It is both an honor and a privilege to deliver the vote of thanks on this momentous occasion. First and foremost, I extend our deepest gratitude to the Honorable Mr. Justice Abhay S. Oak, Judge of the Supreme Court of India, for your gracious presence. Your lecture has been truly enlightening and thought-provoking. It is a testament to your vast experience, unwavering commitment, and dedication to upholding the ideas of the justice in our country. Of everyone present, I express our sincere thanks and deep appreciation to both of you for sharing your time, knowledge, and wisdom with us today. I would also like to thank Honorable Justice Rajesh Bindalji, Honorable Mr. Justice Dipankar Datta Sahab, Honorable Mr. Justice Bagchi, Honorable Mr. Justice K.V. Viswanathan Sahab, learned Attorney General of India, Mr. Vipin Nair, the President of SCORA, Mr. Amit Sharma, Vice President of the SCORA, and Mr. Nikhil Jain, the Honorary Secretary of the SCORA, and also to the other executive member of the SCORA staff and the Bharat Mandapam staff who have worked really hard to make this event a grand success. And of course, at the end, I would like to thank to all of you who have taken out time to attend this gathering. Dhanyavad, Jai Hind and Jai Bharat. So we are concluding now our first session. Honorable CGI will, and along with the other honorable judges, will join us shortly. And it will take a little time, and hardly maximum 5 to 10 minutes. They will be joining us shortly, or maximum 10 minutes or 15 minutes. Yeah. Please. Huh? See, yeah, I would actually request all the guests not to leave the hall because the honorable CGI along with the other honorable judges may really join us soon. Thank you.
May I request everyone to please take their seats? Our chief guest is here. May I request the Honorable Chief Justice of India? May I request, sir, to kindly come on the dais, please. Along with Justice Gavai and Justice Suryakant, please. And I would also request Mr. R. Venkatramani, Attorney General of India, and Mr. Tushar Mehta to kindly come on the stage. विश्व के सबसे बड़े संविधान का खिताब हमने पाया है। पूरे विश्व में लोकतंत्र का डंका हमने बजाया है। भारतीय संविधान बाहर से संघात्मक है, लेकिन उसकी आत्मा एकात्मक है। It is this unity that is the strength of our nation, and our constitution is the thread that binds us in oneness, ensuring justice, equality, and fraternity for all. In diversity, we find our strength. In unity, we find our purpose. The Indian Constitution has, over the last 75 years, united us as one nation, one people, and one shared destiny. Dignitaries on the dais, Honorable Justice Sanjeev Khanna, Chief Justice of India, Honorable Justice B.R. Gavai, Judge, Supreme Court of India, Honorable Justice Suryakant, Judge, Supreme Court of India, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Solicitor General of India, dignitaries of the dais, Honorable Judges of the Supreme Court of India, law officers, senior advocates, members of the Executive Committee of the Supreme Court Bar Association, all the other members of the bar, their families, and all the guests who have graced us with their presence today. Namaskar and a very good evening to all of you. I am Asta Sharma, Member Executive, Supreme Court Advocates on Record Association, and it is an honor and a privilege to welcome you all today while we celebrate 75 years of the Constitution of India. We have, in the earlier session, heard Honorable Justice Abhay S. Oak, Judge, Supreme Court of India, on access to justice and the 75 years of the Constitution of India, bridging the gap between the judiciary and citizens, as well as Mr. Tushar Mehta, Solicitor General of India, on 75 years of the Supreme Court as the guardian of the Constitution, evolution, challenges, and the way forward. Before we proceed to the next segment, may I take this opportunity to felicitate the dignitaries on the dais. I call upon Mr. Vishal Prasad, Joint Treasurer, SCORA, to kindly present Honorable Justice Sanjeev Khanna with the planter. May I request Mr. Vikrant Yadav, Honorary Secretary, SCBA, to kindly felicitate the Honorable CJI with the stole. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . May I request Dr. Meenakshi Galtra, Member Executive Scora, to kindly present a planter to Justice B.R. Gavai. May I request Mr. Kaustubh Shukla, Joint Secretary Scora, to kindly present a stole to Honorable Justice Gavai. May I request Ms. Pragya Parijat Singh, Member Executive Scora, to kindly present a planter to Honorable Justice Suryakant. May I request Mr. Sushil Tomar, Joint Treasurer, SCBA, to kindly present a stole to Justice Suryakant. May I request Mr. A. Selvin Raja, Member Executive Scora, to kindly present a planter to Mr. R. Venkatramani, Attorney General for India. May I request Mr. Ajay Bansal, Advocate, to kindly present a stole to Mr. R. Venkatramani, Attorney General for India. May I request Mr. Vinod Khanna, Advocate on Record, to kindly present a planter to Mr. Tushar Mehta, Solicitor General of India. May I request Mr. Snehashish Mukherjee, former Secretary, Scora, to kindly present a stole to Mr. Tushar Mehta. Thank you so much, everyone. I now call upon Mr. Nikhil Jain, Honorary Secretary, Scora, to deliver the welcome address.
Honorable Chief Justice of India, Justice Sanjeev Khanna, Honorable Justice B.R. Gavai, Judge Supreme Court of India, Honorable Justice Suryakant, Judge Supreme Court of India, Honorable Judges of the Supreme Court, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Solicitor General of India, Ms. Rachna Srivastava, Vice President SCBA, Mr. Vikrant Yadav, Honorary Secretary SCBA, Ms. Sashmita Tripathi, Treasurer SCBA, Mr. Sushil Tomar, Joint Treasurer SCBA, other office bearers of SCBA, senior advocates, distinguished members of the bar, esteemed guests, and my dear colleagues. A very good evening to all. It is with great pride and immense pleasure that I welcome you all to this momentous occasion organized by Supreme Court Advocates on Record Association. 75 years ago, on 26 January 1950, India gave itself a constitution, a visionary document that laid the foundation for a sovereign, socialist, secular, and democratic republic. As we commemorate this remarkable milestone, we honor not just the text of the constitution, but also its enduring spirit, which has guided the nation through decades of change, progress, and challenges. Drafted under the leadership of Dr. B.R. Ambedkar and the esteemed members of the Constituent Assembly, our Constitution embodies the principles of justice, liberty, equality, and fraternity. It is a living document evolving through judicial interpretation and amendments to meet the aspirations of the people. Over the last 75 years, the Indian Constitution has been the bedrock of our democracy, ensuring the protection of fundamental rights, the separation of powers, and the rule of law. It has empowered institutions, upheld the independence of the judiciary, and strengthened the voices of citizens nationwide. This celebration is an opportunity to reflect on our journey, acknowledge the challenges ahead, and reaffirm our commitment to constitutional values. It is a time to appreciate the role of the judiciary, legal fraternity, policymakers, and citizens in upholding and preserving the sanctity of this grand charter. As we move forward, let us continue to embrace the ideals enshrined in our Constitution and work together to build a just, inclusive, and progressive India. The 75th year is not just a marker of time, it is a call to renew our dedication to democracy, governance, and justice for all. While we relish and celebrate 2025 and this occasion, the year also marks a special milestone for our association as we gather today for the highly anticipated launch of the Scora e-journal and a revamped website. These two initiatives mark a significant step in our commitment to promoting knowledge, professional development, and collaboration within the legal profession. The Scora e-journal is an endeavor to create a platform for knowledge sharing, bringing together not just scholarly legal articles, but also poems, short stories, law and humor by our esteemed members. It is a testament to the diverse intellect, creativity, and perspectives that enrich our profession beyond the courtroom. We hope this journal will serve as a space for legal discourse, academic exploration, and a celebration of the literary and artistic talents within our community. Alongside, we are also proud to unveil the revamped Scora website designed to be more dynamic, accessible, and resourceful digital interface. In an era where technology is seamlessly integrated into legal practice, this platform will serve as a hub for information, updates, and professional networking, ensuring that our members remain connected and well-informed. As we celebrate these forward-looking initiatives, it is also a moment to reflect on the dedication and legacy of those who have paved the way for us. We are deeply honored to felicitate advocates on record who have completed 50 years at the bar, a remarkable achievement that speaks of their unwavering commitment to the legal profession and their invaluable commitments and contributions to the institution of justice. Their journey is an inspiration to all of us, reminding us of the profound responsibility we bear as officers of the court. I take this opportunity to express my gratitude to our esteemed guests for gracing this event with their presence. Their leadership and guidance continue to shape and strengthen our legal system, and we are truly privileged to have them among us today. I also extend my heartfelt appreciation to the Executive Committee of Scora, our dedicated members, and everyone who has contributed to make this event a reality. It is through our collective efforts that we continue to grow as an institution, upholding the values of justice, integrity, and excellence. With that, I once again welcome you all and look forward to an engaging and enriching evening ahead. Thank you.
Thank you, sir. I now call upon Mr. Vipin Nair, President, Supreme Court Advocate on Records Association, for his address.
Honorable Chief Justice of India, Justice Sanjeev Khanna, Justice B.R. Gawai, Justice Suryakant, Justice Bhatti, Justice Arvind Kumar, Justice Koteshwar Singh, Rachna Srivastav, Vice President, SCBA, and on the dais, our esteemed Attorney General, Venkatramani Saab, the Solicitor General, who is also the Scora captain, cricket captain, and all the Bhishma Pitamas who are in the corner who spent 50 years of their life as advocate in records and practitioners. Your blessings are required for this function. You are the stars of this show. We deeply appreciate the commitment and the dedication that you have given us. Continue to look for your guidance. Brothers and sisters, Namaskar. 75 years ago, the framers of our constitution, led by Baba Saheb Ambedkar, crafted a document that was truly revolutionary in its inclusiveness, blending the finest principles of liberty, equality, and fraternity. What he said was very important. He says, Constitution is not merely a lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. This Magna Carta, established in India as a sovereign democratic republic, while remarkably preserving its unity in diversity. The preamble's solemn word, "We the people," marked the beginning of an extraordinary experiment in constitutional democracy that continues to inspire the world. From Kerala's Kashwananda Bharati to Kashmir's 370, the legal journey of Supreme Court has ensured that the Constitution remains the supreme law of the land. From abolishing untouchability to implementing reservations, from recognizing privacy as a fundamental right to decriminalize homosexuality, our judgments reflect the society's evolving conscience, while maintaining remarkable stability despite numerous challenges. Over 7 decades, our Constitution has proved to be a dynamic, living document, adapting to changing times while protecting its core values. Through almost 104 constitutional amendments, it has expanded rights, strengthened federalism, and promoted social justice. The SCORA, by way of its timely judicial interventions, has always been in the forefront of protecting the independence of judiciary. We will continue to do so. Chief Justice, in this 75th year, we also look up to you, your leadership, to guide the judiciary through the turbulent times that we face. But today is a moment of celebration. We will be shortly launching our chronicle and a website which promises to make the daily life of AWARs better. I'm thankful to all the judges who have come here on a busy day, and just look at the crowd. They're all here to hear you. Thank you. Jai Hind.
Thank you, sir. May I now request Mr. Tushar Mehta, Solicitor General of India, to come up for his address kindly.
Good evening again, friends. My Lord Chief Justice of India, my Lord Justice Gawai, my Lord Justice Suryakant, Justice Arvind Kumar, Justice Bhatti Sahab, and my Lord Justice Kotishwar Singh, and all friends. Friend, I know I see all the faces who were there in the first function, and my biggest contribution in this function would be this. I concur with whatever I have said 1 hour before, and I adopt my earlier speech. For those who were not present here during my earlier speech, including the honorable judges, I can assure them from bottom of my heart and with all sincerity at my command that you have not missed anything worthwhile. Thank you so much.
Thank you so much, sir. May I now request Mr. R. Venkatramani, Attorney General for India, to kindly come up and address the august gathering.
I wish I also concur with my learned brother. But I think he's so short and sweet, and he can easily steal people's hearts with his sweetness. But let me appreciate the SCORA with this wonderful function which is being organized today. Sisters and brothers, and on behalf of all of you, I take the opportunity of welcoming and greeting Chief Justice Sanjeev Khanna and 2 honorable judges, Chief Justices in waiting, and the bar, the Supreme Court bar, is a microcosm of the nation. It reflects the movement and migrations of people from all over the country to congregate in one important place called the Supreme Court of India. If politics is wedded to democracy, and so it must be, and if democracy must be wedded to justice, and so it must be, and what are we wedded to? I think the bar is not merely a limb of the court, but it reflects much more beyond being a limb of the court. So when celebrations like this happen, particularly when you're talking about the 75 years, and after having listened to a very interesting and a thought-provoking speech by both Solicitor and Justice Oka, I went into introspection as to what the bar is called upon to do in the next 75 years. Many of us who are not part of the previous 75 years, well, I think we will look forward the next 75 years when you would have probably being a proud part of making the Constitution of India an enduring document. As long as the Constitution endures, we are part of this endurance. So our role, I think, I suppose, in the next 75 years is to ensure that the Constitution will continue to endure as it has, despite all the little internal domestic challenges which the Constitution, the people of this country, and the governor of this country has faced. I think later deeper reflections are called for when you talk about another 75 years. It's easy to write about the chronicles of the Supreme Court and the way the rule of law has evolved in our country. We can chronicle them. We can talk about how Supreme Court played a very important role. But if we need that to ensure that this role continues to be there as part of the nation's history, I think the bar will be doing a greater service by being integral to that. And I suppose that evenings like this are a great reminder that each and every one of us will continue to play that very important role. I wish to conclude. I've been recently engaged in some very what called introspective exercises after assuming this office. I must say that very publicly, that these 3 years of experience as Attorney General has brought me close to how governance is a very difficult and a challenging subject. It's brought me close to understanding how the Supreme Court, with all its challenges, will function and make all the balances work without there being too many rips and issues. I think I thank both the government and the Supreme Court for the opportunity of observing it very closely, and therefore I think probably if I continue to remain with you as part of the bar, I'd play that very important role on how to make balance work in our community, in our justice system. Very, very important. Now I'll only conclude by saying that there are many younger members of the bar here, sisters and brothers who entered the bar in the past 10, 15 years. And there are many questions which are before you as individual practitioners. But I suppose you go beyond your professional individual practice when you are wedded to the Constitution. Every day morning, I walk into the court and then walk back away from the court. I ask myself a question: what is that the court was doing today? Day before yesterday, I was sitting in Chief Justice's court. Watching the court very closely, I went into a very deep reflective mode. What a beautiful place this is. A court where people are able to place their faith and then able to say that what I place before the court is received respectfully, regardfully, and very thoughtfully. And that place brings about resolutions of all that we think we cannot resolve ourselves. I think we must place as much importance as possible to this institution, which makes democracy, justice, and peace survive in our country. I will vote without any reflection, without any question on the importance of the institution. Let us vote it in favor every minute and every day of our practice. And every day when I go to bed, I ask myself a question again: have I done something good for the community? Has the world been better by doing something good for the community? I wish that each and every one of you has the same question every day, every morning, and continue a journey with the rule of law journey with the nation adopted 75 years ago. I wish each one of you have that wonderful journey.
Thank you so much, sir. May I now request Honorable Justice Suryakant, Judge, Supreme Court of India, to kindly say a few words.
Justice Sanjeev Khanna, Honorable Chief Justice of India, Justice Bhushan Ram Krishna Gavai, Senior Most Judge, Supreme Court of India, my esteemed colleagues from the Supreme Court of India, Dr. R. Venkat Ramani, Attorney General for India, Mr. Tushar Mehta, Solicitor General of India, Mr. Vipin Nair, President, Supreme Court Advocates on Record Association, other office bearers and members of the SCORA, Vice President, Secretary and other office bearers of the Supreme Court Bar Association, members of the bar, a very distinguished team of AORs who have completed 50 years in the service of this institution, friends from media, ladies and gentlemen. It's with great pleasure and deep appreciation that I stand before you today on this remarkable occasion, on the inauguration of the revamped e-journal and website of the Supreme Court Advocates on Record Association. And also, most importantly, the felicitation of those advocates on records who have completed 50 years of distinguished service. I extend my heartfelt congratulations to SCORA for this remarkable initiative, which will not only serve as a dynamic repository of legal knowledge, but also strengthen the intellectual and professional ties within the legal community. This initiative is a testament to SCORA's commitment to excellence and progress. Today, as we acknowledge the role of AORs in the legal system, it is imperative to reflect on their significance of this institution. As you know, the system of advocates on record introduced way back 1966 is a unique feature of the Supreme Court which ensures that qualified advocates who possess the requisite skills and expertise are entrusted with the responsibility of drafting and filing cases before the highest court of the land. This is not merely a procedural requirement, but a recognition of the vital role played by AORs in safeguarding the integrity of litigation before the Supreme Court. The AORs are not just advocates. They are the custodians of the due process, the bridge between the litigant and the judiciary, and the first checkpoint to ensure that only meritorious cases reach the Supreme Court. At the heart of this responsibility lies the art of drafting, which is arguable one of the most critical skills for any legal practitioner. A well-drafted petition or submission is the foundation of every case, setting the tone and direction of legal proceedings. The importance of precise, well-reasoned, and cogent drafting cannot be overstated. It's often the difference between a case being admitted or dismissed, between clarity or confusion, and between relief being granted or denied. Equally important is the ability to present complex legal arguments in a clear and structured manner. An articulate and lucid document is not just about correct language and formatting. It reflects deep legal understanding, strategic thinking, and thorough preparation. It is this skill that transforms a mere legal document into a powerful instrument of advocacy, making it an indispensable tool in the hands of a proficient AOR. It is in this context, my young friends, that I must sound a word of caution about the growing tendency toward copy and paste and use of automated drafting softwares. While technology undoubtedly has its advantages and can serve as an aid in research and organization, it can never replace the intellectual rigor, analytical depth, and human intuition that are the hallmarks of a skilled AOR. The craft of legal drafting is not merely about stringing together well-phrased sentences. It is also about understanding the nuances of law, anticipating counter-arguments, and tailoring each petition to the unique facts and legal framework of the case. Artificial intelligence, I doubt, has the degree of ability to exercise judgment, comprehend context in its complete sense, and capture the subtleties of advocacy that make the difference in a court of law. I urge all the AORs, particularly the younger generation, to place trust in their own legal acumen rather than relying on ready-made material for the essential skill of drafting. Our profession is built on the twin pillars of precision and reasoning, both of which require the human intellect honed through years of study, experience, and practice. Instead of turning to technology as a crutch, I encourage you to refine your own drafting skills through rigorous practice, deep engagement with case laws, and constant learning. Another key aspect which must be emphasized today is that the true measure of an AOR success is not the number of cases filed, but the impact and quality of their legal submissions. In a profession where time is limited and efficiency is paramount, we must ensure that we do not dilute the standard of legal practice in the pursuit of volume. I beseech each of you to focus on crafting submissions that are succinct, persuasive, and backed by sound legal reasoning. A single well-drafted petition can leave a lasting impression on the bench and contribute meaningfully to the evolution of law. As we celebrate the achievements of our senior AORs who have completed 50 years in this esteemed profession, let us take inspiration from their dedication, resilience, and commitment to the rule of law. Their journey is a testament to the virtues of diligence, ethical practice, and lifelong learning. To the younger AORs in the audience, I say this: aspire not just to file cases, but to shape jurisprudence, not just to argue, but to persuade, and not just to practice law, but to uphold justice. The legacy of the Supreme Court of India is built on the shoulders of its bar, and it is through your tireless efforts that this legacy will continue to grow. I once again congratulate SCORA for its commendable initiative in launching the revamped e-journal and website. May it serve as a beacon of knowledge, a platform for legal discourse, and a repository of the finest legal minds in our country. To all the AORs present here, particularly those who have completed 50 years at the bar, let this occasion be a reminder of your pivotal role in the justice delivery system and a reaffirmation of your commitment to excellence. The Supreme Court looks at you as its first line of defense against frivolous litigation and as the torchbearers of legal integrity. May you continue to serve with distinction, uphold the highest standards of advocacy, and contribute meaningfully to the pursuit of justice. Thank you very much. Jai Hind.
Thank you, Your Lordship, for your kind words, which never fail to inspire us all. May I now request Honorable Justice Bhushan Ramkrishna Gavai, Judge, Supreme Court of India, to kindly say a few words.
The Honorable Chief Justice of India, Justice Sanjeev Khanna, my esteemed colleague Justice Suryakant, my esteemed colleagues Justice Arvind Kumar, Justice Bhati, and Justice Koteshwar Singh, Mr. Venkatramani, the learned Attorney General for India, Shri Tushar Mehta, the learned Solicitor General, Shri Vipin Nair, the President of SCORA and all the other office bearers of SCORA, the office bearers of the Supreme Court Bar Association, the learned senior counsels, the advocates on records, and dear friends. My heartiest congratulations to SCORA for hosting this conference commemorating the 75 years of the Constitution of India. The Constitution embodies the hopes and dreams of the Indian people. The framing of India's Constitution was driven by a collective vision to empower every citizen, safeguard their rights, and uphold justice, equality, and dignity. Rooted in the principles of equality, liberty, and fraternity, the Indian Constitution promotes social democracy and strives to bring about positive societal transformation. As Dr. Ambedkar said in his last address to the Constituent Assembly, and I quote him, "We must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at its base a social and economic democracy." In the last 75 years, the Supreme Court of India has been at the forefront of shaping the country's constitutional mandate. Through judicial review, the Indian judiciary has been instrumental in interpreting constitutional provisions, invalidating unconstitutional laws, and upholding democratic values. The largest ever bench of 13 judges in the landmark case of Keshavanand Bharati versus the state of Kerala held that the core principles forming the basic structure of the Constitution could never be abrogated even by the constitutional amendment. The judgment listed several basic features of the Constitution, such as supremacy of the Constitution, republic and democratic form of government, secular character of the Constitution, separation of powers between the legislature, executive, and the judiciary, and federal character of the Constitution. In Minerva Mills versus Union of India, the Supreme Court cemented a harmonious balance between Part 3 and Part 4 of the Constitution. It was held, and I quote, "The Indian Constitution is founded on the bedrock of the balance between Part 3 and Part 4. To give absolute primacy to one or the other is to disturb the harmony of the Constitution. This harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. The basic structure doctrine is a fundamental pillar of constitutional interpretation in India. It has been reaffirmed through several landmark judgments. Another significant case is of Maneka Gandhi versus Union of India, where the court held that the procedure established by law must be fair, just, and reasonable. The court emphasized that the provisions of the Constitution must be read together. Over the last 75 years, the Supreme Court has expanded the scope of Article 21, incorporating various rights to ensure the full realization of the essence of the right to life, such as the right to live with human dignity, right to shelter, right to health, right to sleep, right to protest, right to clean air or water, right against noise pollution, right against illegal and wrongful detention, right to free legal aid, right of arrested persons, right to food, right to privacy, and the right to protection from the adverse effect of climate change. Every day, hundreds of citizens step into the court seeking justice, a testament to their unwavering trust in this institution. The presence reflects not only their faith in the judiciary, but also the fundamental role of the court plays in upholding the rule of law, protecting rights, and ensuring justice for all. This trust is a responsibility that the judiciary carries with utmost dedication, reinforcing its commitment to fairness, impartiality, and the principles enshrined in the Constitution. I must, on this occasion, place on record my appreciation for the services rendered by all the advocates on records from 1966 in assisting the Supreme Court in discharging its duties. I extend my heartfelt congratulations to SCORA on the launch of its e-journal and the successful revamping of its website. This initiative will undoubtedly contribute to the dissemination of legal knowledge and promote meaningful discussions within the legal community. I also take this opportunity to commend and congratulate the advocates on record who have completed 50 years at the bar. Their invaluable contributions to the legal profession serve as an inspiration to the entire legal fraternity. Their unwavering commitment to justice and the rule of law has strengthened our legal system, and I express my deep appreciation for their service. I once again thank the office bearers of SCORA for organizing this conference to celebrate 75 years of the Constitution of India. I extend SCORA and all its members all the best in their future journey. Thank you very much.
Thank you, Your Lordship. We are privileged to have had the opportunity to learn from you, and we look forward to more such enlightening discourse in the future. May I now request Honorable Justice Sanjeev Khanna, Chief Justice of India, to kindly say a few words.
Namaskar and a very good evening. My esteemed brothers, Justice Gavai, Justice Surikant on the dais, Justice Arvind Kumar, Justice Bhatti, Justice Koteshwar Singh, who's sitting amongst the audience, the Attorney General of India, the philosopher amongst us, Mr. R. Venkataramani, Mr. Tushar Mehta, the Solicitor General of India, Mr. Vipin Nair, President Supreme Court Advocates on Record Association, Mr. Amit Sharma, Vice President of the Supreme Court Advocates on Record Association, office bearers, executive committee members, members of the Supreme Court Bar Association, ladies and gentlemen. 4 significant milestones get combined today. 75 years of Indian Constitution, the launch of SCORA e-journal, unveiling of revamped website, and recognition of our advocates on records who have reached 50 years at the bar. I was just wondering today, when we talk about judiciary, first thing which comes to the mind of most people is judges.
But judiciary is not judges. When we refer to the judiciary, we refer to the judges as well as the bar. Without the bar, we are incomplete. There cannot be any judiciary. The second aspect which came to my mind was, what makes judiciary unique? Legislators are elected by the people. They are representative of the people. They are a handful. The executive, political executive, is in a parliamentary democracy, is answerable to the parliament or the legislature. What makes judiciary unique is our direct connect with the people. The most easy access, which if the people have access to any of the three institutions, the most easy access is to the judiciary. It's in the judiciary that anybody can raise any grievance and ask for explanation, even against the state, even challenge constitutional vagaries of a legislation, you can ask for enforcement of constitutional rights, statutory rights. And it's so easy to walk into any court, engage a lawyer, engage or even argue in person. That means we are the ones who are directly associating ourselves with the people. That is our strength. Now I'll come to the SCORA e-journal. I feel there is one aspect which has been lacking amongst the bar members. It was possibly there if one goes through Sir Vice Constitution of India and certain other, or for that matter, G.P. Singh's interpretation of statutes, is critical analysis. I hope this SCORA e-journal will one day become the journal wherein you will have critical analysis of Indian jurisprudence, Indian legal thought, Indian judgments, and contribute worldwide. For this, what do you have to do? We want the younger members of the bar, the elder member of the bar, to write their viewpoints, to explain how the judgments have erred or how the judgments have promoted the Constitution of India, the jurisprudence behind the Constitution of India. You must bring in fresh perspectives. I hope the academia, the law students, and of course the advocates will contribute to the SCORA's journal. I hope to see SCORA's journal turning out to be an excellent platform of convergence and ultimate dissemination of ideas. The second is the revamped SCORA website, a new platform which enhances communication and interaction with our community. It is designed to make it easier to access information, stay connected, engage more effectively with the development that matter most. The upgrade ensures that we remain in the forefront of digital tools and maintain a space for seamless communication. We have brought in technology across the board in the judiciary, including the Supreme Court. It's time that we start using that technology to the best so that our judicial system works better. Ease and convenience certainly matters. Lastly and finally, perhaps the most important thing is the honoring, the Bhishma Pratama, as Mr. Nair said, of our legal fraternity. Advocates on record who have achieved the extraordinary milestone of 50 years at the bar. 50 years is an achievement that speaks both longevity and a deep, enduring commitment to the profession. These advocates have contributed immensely to the profession, not only through their individual practices, but by shaping the practice itself with their insight, mentorship, and leadership. Today, we recognize their contribution and lasting impact they have had on the profession. I want to say something. We have often talked about judges and advocates being two wheels of the chariot. I had a slightly different quote, which is from a judgment way back in 2001 in D.P. Chadda's case. It goes like this. It has been a saying as old as the profession itself that the court and the councils are two wheels of the chariot of justice. In an adversarial system, it is more appropriate to say, while the judges hold the reins, the two opponent councils are the wheels of the chariot. While the direction of the movement is controlled by the judge by holding the reins, the movement itself is felicitated by the wheels without which the chariot of justice may not move and may collapse. Please ensure we do not collapse. That's as we celebrate the launch of eJournal, the new website, and the remarkable careers of our senior advocates, we are reminded of the importance of both innovation and tradition in our fields. These milestones reflect on our ongoing growth and solid foundations on which our work is built. Thank you, and Jai Hind.
Thank you, Your Lordship, for your kind words of wisdom and your continued support to our association. The Supreme Court Advocates on Record Association is proud to present its newest initiative, Suo Motu, the Scora Journal, a unique compilation that blends legal scholars with creative expression. This journal is not just another legal publication. It is a first-of-its-kind endeavor that brings together articles, poems, short stories, and humor related to law, offering a refreshing and insightful perspective on the legal profession from the Supreme Court corridors. As legal practitioners, much of our writing is confined to the precision of petitions, affidavits, and written submissions. While these are integral to our profession, the ability to rethink, analyze, and express beyond the rigidity of legal drafting is equally important. The Scora Journal seeks to encourage members of our association to explore their insights, experiences, and even the lighter side of the legal practice. The first edition being inaugurated today will be both in physical and digital version. However, the first edition being inaugurated today will be both in physical and digital version. However, from the next edition, the Scora shall only be publishing the journal in a digital version, wherein all the stakeholders can access the publication on their phones, iPads, and laptops. The indexes of the digital version are all hyperlinked for smooth access and navigation of the publication at your fingertips. We invite all our colleagues to contribute, engage, and be part of this exciting new initiative as we celebrate the power of the written word in shaping legal discourse and beyond. Before we move ahead, I would be amiss if I do not introduce our esteemed editorial board comprising of Dr. Charu Mathur, Ms. Pallavi Barua, Ms. Aparna Jha, Mr. Puneet Singh Bindra, Mr. Prasanna S., and Mr. Amit Pai, advocates on record, who extensively scrutinized all the submissions made, spent endless hours making edits, engaging with the authors, and assisted us to present this journal to you today. Two more names that need a special mention at this point are those of Mihika and Shlaga Jindal, the dynamic sister duo, one based in Paris, the other in Delhi, who took on the Herculean task of designing our e-journal under their banner, the Enthu Cutlets. They not only understood our concept and vision, but went over and beyond our expectations with the final layouts, and this journal is a reality today because of their hard work and meticulous designing. And we are delighted to have them here today from all the way from Paris. May I call the editorial board and the Enthu Cutlets one by one on the stage to kindly accept a small token of our appreciation, and may I request Honorable Chief Justice of India, Justice Sanjeev Khanna, to felicitate the editorial board. Dr. Charu Mathur, advocate on record. Ms. Aparna Jha, advocate on record. Ms. Pallavi Barua, advocate on record. Mr. Puneet Singh Bindra, advocate on record. Mr. Amit Pai, advocate on record. Mr. Prasanna S., advocate on record. Ms. Mihika and Shlaga Jindal from the Enthu Cutlets, who've designed the layout for the e-journal. Thank you so much. Moving forward, on behalf of the Justice of India, to kindly announce the launch of the revamped website of the Supreme Court Advocates on Record Association. Thank you so much, sir. As we gather today in this momentous event, it is only fitting that we take a step back in time to revisit the foundation and early days of the Supreme Court of India, an institution that has stood as the guardian of a constitution and the protector of justice for over 7 decades. The Supreme Court inaugurated on the 28th of January 1950, just 2 days after the Constitution of India came into effect, in its initial years functioned from the Chamber of Princes in the Parliament House, a humble beginning which would later become the highest court of the land. Over the years, the court has evolved in stature, responsibility, and influence, shaping the legal and constitutional framework of our country. Let us take a brief nostalgic journey through a special video curated with the special efforts of our EC, with able assistance from the registrars of the cherishing the legacy of the past after embracing the future and renewed dedication.
It is undoubtedly challenging, it is equally fascinating and rewarding. AORs are the pillars upon which the Supreme Court is standing. Designated as officers of the court, the AORs perform with great responsibility towards the bench and the bar to protect the dignity of the system and uphold the values on the basis of which the system was created. On this occasion, when we are all gathered here to felicitate the senior AORs, it would not do justice if I do not speak about the enormous support, tolerance, and sacrifices made by the family members, the spouses, and the children of the AORs. Missing out on many important family functions and occasions for urgent filings and senior conferences, our families have stood with us with smiling faces. Without their sacrifices, I don't think any AOR can achieve success in this profession. My sincere gratitude to all the family members of the AORs. Completing 50 years at the bar is an achievement in itself. SCORA is delighted to felicitate our senior members today. May I most respectfully request Honorable Chief Justice of India, Shri Sanjeev Khanna ji, Honorable Mr. Justice B.R. Gawai ji, Honorable Mr. Justice Suryakant ji, to kindly come forward to felicitate our AORs who have completed 50 years at the bar with a shawl, memento, and certificate of appreciation. I also request the Learned AG and Learned Solicitor General of India to kindly join. I now request Mr. Bhargav V. Desai to kindly come. Mr. P.D. Sharma. Mr. P.N. Gupta. Mr. Randhir Jain. Miss Lalita Kohli. Mr. Krishan Kumar Mohan. Mr. Rajendra Prasad Saxena. Mr. Sohan Singh Rana. Mr. Charan Lal Sahu. Mr. Manoj Swaroop. Mr. Sif Shagar Tiwari. I request the audience to give a big round of applause. Dr. Sushil Kumar Verma. Mr. B.Y. Kulkarni. Ms. Manjeet Chawla. Ms. Manju Jetli. Mr. Sudhir Kumar Gupta. Mr. Satish Wig. Mr. Ravindra Bana. Mr. N.K. Agarwal. इधर सर Mr. T.L. Garg. I request Rohan Garg to kindly come on stage to collect on behalf of Mr. T.L. Garg. Ms. Mehak Karanjawala on behalf of Ms. Mani Karanjawala. Thank you.
So, I'm sorry, we missed one name. Miss Bindra Rana is also here.
Mr. Vijay K. Jain. Mr. Shripal Singh. Vijay Kumar Verma. Mr. Vijay Kumar Verma. Mr. Vijay K. Jain. Thank you once again.
Thank you so much, everyone. That's it. Thank you so much, everyone. Last but not the least, in the series of felicitation, may I take this opportunity to felicitate our esteemed guest for joining us today and making this event truly memorable for all of us present here. May I request Mr. D.K. Garg, former President SCORA, to kindly come up on stage and felicitate the Honorable Chief Justice of India, Justice Sanjeev Khanna. May I request Mr. Vipin Nair, our President SCORA, to kindly present a photograph to Justice Sanjeev Khanna, Chief Justice of India. May I request Mr. Anurag Singh, Advocate, to kindly come up and present a memento to Honorable Justice B.R. Gavai. May I request Mr. Amit Sharma, Vice President Scora, to kindly present a photograph to Honorable Justice B.R. Gavai. May I request Mr. Kunal Chima, Advocate, to kindly come and present a memento to Honorable Justice Suryakant. May I also request Mr. Nikhil Jain, Honorary Secretary Scora, to kindly present Justice Suryakant with the photograph. We just have 2 more photographs to go. May I request Mr. MP Parthiban, Advocate, to kindly come and present a memento to Mr. R. Venkatramani, Attorney General for India. May I request Mr. Kaustubh Shukla, Joint Secretary Scora, to kindly come and present a photo to Mr. R. Venkatramani, Attorney General for India. May I request Mr. Raj Kamal, Advocate and Record, to kindly present a memento to Mr. Tushar Mehta, Solicitor General of India. May I request Ms. Pragya Parijat Singh, Member Executive Scora, to kindly present the photo to Mr. Tushar Mehta. All these beautiful paintings of our dignitaries have been sketched by a member of our association, Mr. Hani Yadav, Advocate. I would like to request Mr. Yadav to kindly come up on stage. We have a small token of appreciation on behalf of Scora to felicitate him for these beautiful paintings. Lastly, may I request Mr. Amit Sharma, Vice President, Supreme Court Advocates of Record Association, to kindly give the vote of thanks and conclude the session closed.
Honorable Justice Sanjeev Khanna, Chief Justice of India, Honorable Bhushan Ramakrishna Gavai, Judge Supreme Court, Honorable Mr. Suryakant, Judge Supreme Court, Honorable Justice N. Koteshwar Singh, Judge Supreme Court, Mr. R. Venkataramani, our Attorney General for India, Mr. Tushar Mehta ji, our Solicitor General of India, Mr. Vipin Nair, President SCORA, Mr. Nikhil Jain, Secretary SCORA, esteemed honorable judges, learned seniors, past and present office bearers of SCORA and SCBA, Ms. Rachna Srivastav, Vice President SCBA, Mr. Vikrant Yadav, Secretary SCBA, Mr. Anil Nishani, Member Executive SCBA, Ms. Jyoti Parashar. There are many, the list is long, so all the office bearers. The esteemed editorial board, already been described, distinguished guests, and my dear colleagues, Pranam. It's my absolute honor to stand before you and express our heartfelt gratitude on behalf of the entire SCORA team. With immense pride, I deliver this vote of thanks on this historic occasion, celebrating 75 years of the Constitution of India and our shared commitment to justice and progress. As the curtain falls on this momentous occasion, we are deeply humbled that the universe aligned to help SCORA realize yet another meaningful initiative. No great initiative succeeds alone. It is the collective effort of all involved that makes it possible. A heartfelt gratitude to our Honorable Chief Justice of India, honorable judges, respected Attorney General, respected Solicitor General, senior advocates, and the entire legal fraternity. Your presence has elevated this event into a true celebration of legal excellence. As the Honorable Chief Justice of India, Justice Sanjeev Khanna, profoundly stated, I quote, "The Constitution has transformed the country," unquote. Today, the transformative spirit is mirrored in our august gathering, more so with his presence, enriching this event and inspiring us to uphold the values with greater commitment. We extend our deepest gratitude to Honorable Justice B.R. Gavai for his esteemed presence, which has greatly enriched this occasion and reaffirmed the values that guide our legal profession. As Justice Gavai had observed, I quote, "Artificial intelligence in judiciary must not replace human mind and judgment," unquote. The SCORA e-journal stands as a reflection of this principle, not crafted by algorithms, but a product of human intellect and diligence of dedication of advocates on record. A heartfelt thanks to the authors and contributors whose articles have enriched legal discourse, and to the entire editorial team whose meticulous work has ensured the highest standards of quality. We are deeply grateful to Honorable Justice Suryakant ji for his esteemed presence and insightful words, which have added a great significance to this occasion. As Justice Suryakant ji cautioned, I quote, "Justice delayed is justice denied, but justice inaccessible is justice undone," unquote. The newly revamped SCORA website undertakes to serve as a vital bridge between advocates of the Supreme Court and wider community, and ensures that legal recourses and collaboration are within reach of all who seek justice, not just for privileged few. Our special gratitude to esteemed Attorney General, Mr. R. Venkataramani, for his valuable support, a learned jurist and a guiding force. We are deeply indebted with gratitude to our distinguished Solicitor General of India, Shri Tushar Mehta ji, whose wholehearted support made it possible for us to host this event at the prestigious Bharat Mandapam. As it was also the venue for the 75-year commemoration of the Honorable Supreme Court, it was only fitting that we gather here once again, this time with even more members of the Supreme Court fraternity, to celebrate 75 years of the Constitution of India, making this occasion truly inclusive and accessible. Heartfelt congratulations to the esteemed advocates felicitated for 50 years of dedicated service to the legal profession. And finally, to our audience, senior advocates, advocates on record, advocates, and legal professionals, you are the heart of this event. Your presence, engagement, enthusiasm, and commitment to the law, meaning to initiatives like this. We sincerely regret that we could not extend invitations to everyone who wished to be a part of this event, and we deeply miss the presence of those who were unable to attend. We, the advocates, stand alongside honorable judges as an upholder of the Constitution. It is not just a responsibility, but a privilege to protect the ideals of justice, liberty, equality. Every case we argue, every precedent that we set, and every reform that we champion is a step ensuring that the Constitution remains a living, breathing document that serves the people. I would also thank Mr. Radheshyam Bajaj, who's the co-founder of SIB Infotech, who has been instrumental in designing the website of Scora. I would also acknowledge Mr. Radhe, who had also taken a group photograph. In the spirit of gratitude, let us recall the wisdom of Bhagavad Gita. Yat karoshi, yadas nasi, yaju hosi, dadasat yat. Yat tapasi, konte tatvakus madarpanam. Whatever you do, whatever you give, do it as an offering to the higher purpose. Jai Hind. And I would also request that we'll have a full group photo, so just kindly gather in the down.
And can we have the supporting staff members of Scora as well?
I would also request the supporting staff of Scora to kindly come for the executive committee group photo.
I request everyone to kindly join us for dinner, please. We also have copies of the Scora journal with us. Request members to kindly collect the same before they head out for the night. Thank you so much, everyone.